So I'm Maryann Duncan. So I've worked as a paralegal in the Treasure Valley for 20 plus years. 11 years of that, I worked for law firms, estate and trust companies. So I've worked in the estate and trust administration for about 11 years. So I'm not an attorney, but I thought I would share stories of what I've seen and things that, make you think about when you're meeting with your attorney, your CPA, to do your estate planning, because these are some of the things that you may not have that discussion with the attorney unless you know ahead of time, because attorneys are going to advise you on the risks, on tax strategy. Your CPA is going to advise you on tax strategy, but I'm going to share with you some stories of what we actually see when we're administering estates. So I'm happy to be here. I don't know who is the creative person put this presentation together, but they're much more eloquent than I am. What you don't know about estates could cost you. So this is the goals they put, is to take a good look at the details. And part of that is so you're prepared to meet with the attorney, and that's going to be more cost effective because everybody knows attorneys bill by the hour. And if you are going to put real estate in your estate planning documents, I would recommend you hire a good attorney that does trust, that does real estate. You don't want to go cheap because mistakes are costly. Another goal is to provide a clear understanding of the complexities surrounding passing along real estate through your estate, share helpful information for you to ponder. I included a handout. I did a little bit of research. I do not work with trusts that hold and manage real estate. My specialty is more with special needs trusts. So, but my company does, and I can provide that information, but this is not a company sponsored presentation. I just wanted to share with you my experience over the last several years. Reminders of the important steps to take now and practical tips. So one of the things, I worked with an attorney, and one of the things when we would meet with clients and say what, to figure out your estate planning, some key things to think about ahead of time is know your beneficiaries. Who is going to inherit this property? How long do you want the property to stay if you're going to put it in a trust? How long do you want it to stay in the trust? How many generations? There are limitations for how long properties can stay, but you want to think, do you have minors? If your beneficiaries are minors, their share is going to need to go into a children's trust, because it is not advisable at 18 for an 18-year-old to inherit a lot of money or property to manage. They're just not going to be able to do that. You want to think, do they have special needs? Do you have beneficiaries that have disabilities? If you do have a beneficiary that has a qualified disability, you want to make sure that they're not inheriting that money directly, that you have in your estate planning documents a special needs trust set up for them that will inherit that money, that will protect it from estate recovery later on. You want to consider what's their financial knowledge and experience for handling complex matters. So if you put real estate in a trust, that's complex. So you want to identify, do you have a family member that's qualified to manage that trust? Do you need to reach out to a professional trustee? One thing I did not put on here was a blended family. If you have children from prior marriages, that can create a lot of issues, and you do want to properly plan for blended families. And I'll just throw out kind of some examples as I go. So I was at the law firm creating an estate plan for a family. They had a blended family. The idea was the property, the residence belonged to the husband, married the second wife. The estate plan said everything should go to his side of the family. However, he was the first to pass. So you have the surviving spouse living in the house, and they cleaned it out before the heirs of the father for those children to get to the house. that happens in the real world because there is a gap in time between when someone passes and when you get a personal representative of the estate or the trustee in place. So when a person dies, usually the first thing you want to do is secure the property and ask everybody, please do not take anything until the trustee or the personal representative has had a chance to do an inventory. Because that is what, in real life, that is what happens. There is a lag, there is a gap between when the person dies and when the trustee gets put in place or when the personal representative gets put in place. And that's when the personal property walks out the door, the family heirlooms walk out the door. So that is just kind of what happens. I like to put in here restrictions equal cost. So this is your money. You can put in as many restrictions as you want. You can put in there the beneficiary doesn't get anything if they have a substance abuse problem. And you can put in there the trustee or the executor has to make sure that they have clean drug tests, that they're employed or they're in a treatment program. But the downside of that is all of that time for the personal representative or the trustee to oversee that process, to enforce those rules, is going to be billed to the trust or the estate. So all of those hours to do that, to follow up with that, is going to add cost. And that's not taken, and a lot of people don't take that into consideration. So I like to say, how much do you want to roll from the grave? And let me give you kind of an example of a trust that I currently have. And the grantor's intent was he set this trust up. His daughter is the beneficiary. He set up a requirement that for his daughter to get distributions from the trust, she needs to provide proof of income of over $25,000 a year. That sounds simple enough. However, the daughter is a stay-at-home mom, takes care of kids, works for the school full-time. She does not earn $25,000 a year. She cannot get the money from the trust because she cannot meet that requirement. So these are kind of things to think about when you put those in. What seems really reasonable in her situation, it doesn't work for her. So the money's there. She can't access the money. The trustee can't distribute the money because she can't meet that income requirement. So those are kind of things that you want to think about when you put in these requirements where the trustee, as the trustee, you have to go by what's in the trust. You know, there's discretion, but where that is a hard and fast rule that you have to provide proof of income and she can't provide proof of income. Yeah.
Is that kind of a done deal at that point? I mean, is there any way
Yes.
to open up a trust at all?
So once a person passes, the trust becomes irrevocable as to their share. So Idaho is a community property state. So typically, if you have a trust for a married couple, the first person to pass their assets, that becomes irrevocable. So if you create a trust while you're alive, that's called a grantor trust or a settler's trust. And usually you can revoke that while you're alive. But once you pass, it's irrevocable. And that's the whole point of it, is no one, you know, we have to follow what your decisions are, what you made while you're alive, and what you've put in the legal documents. Okay. So you just want to kind of think about things. Another example I kind of wanted to bring up is the family cabin. For trustees, a family cabin is an absolute nightmare. Most of us will tell you that is not a good idea, because here again, you have to look at how are you going to fund that? It's a really bad idea to just put real property in a trust. You have to have a source of funds. So if you think of a family cabin, how's the property tax going to get paid? How's the utility going to get paid? If you have to share expenses, do all the family agree? If you have to make a decision, will all the family agree? Most families have at least one person that's gonna be a troublemaker. I know I do. It's on my husband's side. She will be a troublemaker. So usually from the administration perspective, we will typically say, that's a terrible idea, is to keep the family cabin. Now, if you have to do that, you need to think about a strategy. Are you going to appoint one person to make the decisions? Or how are you going to do that? Because management of that cabin becomes a nightmare. And it becomes a big burden on the person that you put in charge. Because nobody likes you. I mean, being a trustee, you just have to know, sometimes people don't like you because you have to say no. You know, they may make a request and you just have to say, I'm sorry, we can't do that. So those are kind of things to look at.
Question.
Uh-huh.
So does that go for any real property outside of personal residence?
So there's an article that we printed to share that just talks about the complexity of putting real property and things that you need to think of. Capitalization, how are you going to allocate the net income? And that's not my area of expertise, but I thought the article was pretty telling. So I can't really address that. But one thing, and that kind of leads into the next, my next point, is one thing you want to consider: do you want this property held in trust for the next generation? It's one thing that while you're alive, if you have a grantor trust set up and you put the property into a trust, and that's to take care of you while you're alive, that has language in there that if you're incapacitated, what's going to happen? That's one thing. But when you go to the next generation, you really want to think about the costs that they're not going to tell you about. So when a person dies, that property is going to get, unless the tax code changes, that property is going to get a step up in the cost basis. Does everybody kind of know what that is? Mm-hmm. So the beneficiaries are going to inherit that property at fair market value. If that property is sold, the beneficiaries are going to pay tax on the capital gains from the stepped up value to whatever the sales price was. So I would encourage you to discuss with your accountant, as a tax liability, is it better to sell those properties for that next generation, get the step up in basis, pay just the capital gains on when it's sold? Or is it better to hold it in the trust and pay administration fees for the trust? So every trust company has different fee schedules. Some of them are a flat fee. The two trust companies I have worked for has been a combination of an hourly fee, and that's every hour that you work on the project, and that's usually starting at about $150 an hour and goes up, and an administration fee. And that administration fee is a percentage of your estate. So just as an example, I was meeting with the client, with the CEO the other day, and I don't handle the fees for our company, but this woman had an estate of about $3 million. And so they calculated just that administration fee was $20,000 a year. That doesn't include the hourly fee to manage that trust or the fees to pay a property manager to manage those properties. So I would encourage you, if I were in your situation, I would want to know, when you're evaluating this with your CPA and your attorney, to think, how long do we want this property to stay in the trust, or compare it to what's the tax ramification, because they're helping you with tax planning, versus the costs of administering the trust. Because it gets very expensive, especially if you hire a professional third party to manage your trust. So just kind of throwing that out there as an example. So if you meet with trustees to manage your trust, you want to find out what their fee schedules are, so you can be educated and weigh the balance between, is it better to sell that real estate now after the person dies and take advantage of the tax savings with the step up in cost basis, or is it better to keep it in the trust? You know, and that just depends on your circumstances. Sometimes there's family property you want to keep in there. But that's where you have to look a couple generations down the road to determine what you want your estate plan to be. Do you have someone that can step in and manage those properties for you, or is that going to be an expense that you need to calculate in? And I don't know the answer for you, but that's kind of what I would look at, because trustee fees are quite expensive. So I would meet with your CPA, think about that and say, okay, if we do this, what is it looking like? If we sell it, if we keep it in trust, what is it going to look like? Because those are the fees they're not going to, you know, when you meet with the attorney, they're probably not going to say, well, you have to realize you're going to be paying out of pocket for the trustee fee. And the trustee may hire a third-party property manager, depending on what trust company you use and how they do that. So then you may have another layer of fees to hire a property manager. So just kind of something to be aware of. And then this slide is, I just looked up the downsides of a trust versus a will. So there's a couple of ways to put a trust into place. You can have a trust as part of your will. That is called a testamentary trust. If you do a testamentary trust, that trust does not go into effect until after you pass, when your will goes into effect. If you do a grantor trust, that is a trust you do while you're alive, that can go into effect right away, but you just have to wait. So kind of the downfalls of a trust are the cost and complexity. So you're going to pay an attorney a lot more money to draft a trust than your will, because the trust is going to talk about what happens if you're incapacitated and other things. But trusts are typically more expensive for the attorney to draft. Like I said, there's maintenance fees that you have to pay with the trust. So you've got the trustee fee. You know, if it's a personal trustee, they could charge a fee, they may not. But if you have a professional trustee, you're going to be paying fees. And it's either, sometimes they'll do a flat rate or they'll do that hourly rate and that administrative costs. One of the things, if you put property into a trust, you need to make sure that you actually transfer that property to the trust. If you have a mortgage on that property, you need to look at your loan documents to see if that's a default under the loan, because you're changing the legal owner of the property. You're changing it to the trust. So I would check your loan documents to make sure that that transfer doesn't throw you into a default situation. I've not seen a bank come back and put you in default, but if you look at loan documents, usually it says it's not assignable, that you cannot transfer it. I wanted to share with you a situation that when I was working for the law firm, we had a client come in. She wanted the attorney to help her set up LLCs to put property into the LLC. Prior to her hiring the attorney, she had prepared a quitclaim deed and moved this property from her personal name to an LLC. She got the name of the LLC wrong on the deed. So as the attorneys, we are always like, well, we're going to take what you say, but we're going to do our own due diligence, and we're going to go to the title company and get the vesting deeds and find out what happened. Find out, how the property is really titled. So in our process, we found out that she actually deeded her property to a third-party company. There was a company in town with that legal name filed with Secretary of State. So fortunately for her, the person that she deeded the property to was very nice, and they signed the deed and we deeded it back. But this can happen. You have to be really careful on real estate. If you make a mistake with real estate, it's expensive to fix. Just kind of know that. That was kind of what we, thought of in the law firm. If we make a mistake and we get it recorded, it's expensive to get it back in place. But so you need to be careful. Another downfall of a trust is it lacks court oversight. So if you open a probate of an estate, that is through the court system. In a probate, the personal representative or the executor is required to file an inventory and an accounting. Prepare an inventory and accounting. In Idaho, if everyone agrees, you can waive the right to have it filed with the court so it stays confidential. But the court still has oversight, so that protects you because the court's going to look at that inventory. They're going to look at the accounting and they have the opportunity. The judge can say, this doesn't sound right. Or if there is a beneficiary that's to inherit and they don't like something, they don't like, say there was a property in the will, it was sold, they don't like the terms of the sale, they can object. So you go to a court hearing and they can object. So with a probate of an estate going through the court hearing process, the court process, you do have oversight by the court. A trust, you do not. Most trusts, unless you write it into the trust that you have to file with you register the trust with the court and you have to file accountings with the court, there's no court oversight. So what trusts do is they'll put into place another person called a trust protector, and that's usually an attorney who then will oversee what's going on. But then again, that's another layer of fees. And we had one trust when I was with my previous employer. We paid the attorney $10,000 to do nothing but approve expenses over a certain amount. We did everything and billed it, but there was still that extra layer of fees. So that's kind of a downside of trust, is there is not the court oversight. There's no creditor protection. So when that trust is a grantor trust and is revocable, it's just like your personal asset, but it's in the name of the trust. There is no creditor protection. In the estate process, there's a creditor claim process that you follow, and if the estate doesn't have enough money, there's a system to handle who gets paid first. It's always taxes. Those always have to be paid first. But that is a benefit of a will. And then you have, with the trust, you have a potential of mismanagement by the trustee. So that's where you really want to consider who's that trustee. And if we have time, I have a real horror story of a trustee that mismanaged property and significantly impaired this woman's life. So that's kind of the downsides of trusts. The downsides of wills are, it is a court process. I can tell you in Idaho, it is not an expensive process. In my opinion, it's just a process. I really like how they do it. It's public record, but you can ask the attorney if we can waive the requirement to file an accounting and an inventory. You want to have those done because that establishes the cost basis of when the beneficiary inherits the property, but you can waive the requirement to file it with the court, and so that information does not become public. Wills don't usually address what happens if you're incapacitated. Trusts have that language in there that you will appoint someone that's going to take over. I have seen in wills where people will nominate a conservator in their will. So if anything happens to them, they will already go ahead and pick the person that they want to take over. But to appoint a conservator, that is a court process to get them appointed. Wills only take effect after death. The grantor trust takes effect while you're alive, and there's no asset protection like trusts will have built in to the trust language. So this is you should have, I don't know if you passed out those. So that is I thought it was a pretty good article. And if that's not my area of expertise, but I thought it would give you some points to think about the complex nature of putting real estate into a trust. Let me see. So just very high level, because there's both state and federal regulations that you have to comply with. Another cost of a trust is usually we have to go back in and get a fair market value on the property every 3 years. So that might mean paying for an appraisal every 3 years. So there's another cost you need to factor in. If you have rental income, it needs to be allocated properly with the ongoing capital requirements so that you don't pass through money to the beneficiary that you need for that property. Because the taxes on trusts, if you're paying, so a trust requires a fiduciary tax return, that's a form 1041. The tax rates on a trust are a lot higher than on the individual. So trusts and estates have to pay tax on any income earned above $600, which is not very much. And well, estates are 600, trusts can be 100 or 300. That is not a lot of money. And the tax rate is high. So what typically the CPA will do, they will pass through to the beneficiary the income, any deductions, so the beneficiary reports it on their 1040 at their personal tax rate to save money. But not everything can be passed through. So you're going to pay more for taxes on trusts. So that's another point to talk with your CPA and say, how does that impact me? How is it being taxed as a trust? What you can pass through, what you can't. So I thought this article was a pretty good example. Like I said, this is not my area of expertise, but how important it is that you find someone that if you're going to hire a professional trustee and an attorney, that they work with real estate, they know how to track that income, what to hold back, how to budget appropriately so that the trust works the way it's intended to work. Yes.
The whole selling point of trust, according to trust attorneys, is that you don't have to go through COVID.
Yes.
So if you want to have the trust terminated on death, what's the point of having a trust?
Well, if you're going to have the trust terminate on death, if you're just going to have everything distributed, the attorney will tell you, they'll advise you on your incapacity, the risk, those types of things that the attorneys will advise you. There are a lot of attorneys who say you can avoid probate by putting everything in a trust. Now, I see trusts that have problems and estates that have problems. And so the ones that I have worked with, there's always an asset left outside of the trust. So I have a new estate that just came in this last week. This woman passed away. She was very diligent. Her property's in the name of the trust. Part of her bank accounts are in the name of the trust. Her annuities have the trust listed as a beneficiary. But there's 2 bank accounts that are in her personal name. If those 2 accounts are great enough, her estate is great enough, we're going to be required to open a probate. So usually with your estate planning documents, the attorney will prepare a pour over will, which says anything that's left out of the trust gets poured over to the trust. However, that still requires you to go to court and open a probate. So a lot of attorneys do advise your best option is a trust, but that's why I'm wanting to throw another point of view out there for you to consider, and have that discussion with the attorney, because they're going to be the ones that help you develop that estate plan. But the attorneys don't necessarily see the administration side and the added costs that you have with the administration of a trust. Does that make sense? So the attorney 90% of the attorneys that I've talked to are dead set on you need a trust. There's a handful of attorneys that I've worked with throughout my career that say that's not always necessary, but it's so dependent on your circumstances. It's dependent on who the beneficiaries are. It's dependent on how long you want that property to stay in the trust. So these are the things that you need to think of before you go meet with the attorney so you can have a discussion with them, because they're going to advise you on the risks and taxes, but they're not necessarily going to take into account all of these other things. That makes sense? So that article was just, I thought, was pretty telling on just the complexity of handling real estate. And then we have in here, you need to confirm the trustee is set up to manage those investment properties. And one thing, if you have properties in multiple states, when you interview trustees, you need to make sure that they have a trust charter in those states and they can operate and manage property in those states. So they have the proper authority to do that. Have just some general tips on estate planning. One I've kind of alluded to. Oh, the one thing that the attorneys will advise you is if you have a named beneficiary on your accounts, you can avoid probate. That's true. However, if you have a pay on death beneficiary on your bank accounts, if you have beneficiaries listed on your IRAs and your investment accounts, there is no money there for the family to take care of possibly funeral expenses, administration of your estate, your final tax return. So you really want to think about, okay, yes, that is true. I can avoid probate. All of that can pass out of probate. But what position is that putting my family in? Does the family member have the money to pay for the funeral expenses? Because a lot of times you have to pay that up front. And a lot of family members don't have that kind of money to pay that. So I caution people, don't always put, and you can list your estate or your trust as your beneficiary. That works. But if you have it going outside to direct people, you might leave no money there to handle your final affairs. So just caution you on that. So you can put named beneficiaries on accounts. One thing I advise people is, as an administrator trying to locate the assets, trying to get copies of bank statements, everything, so much is done online anymore. So make sure somebody knows where your PIN numbers and your passwords are. Because you wouldn't think it, but it is very difficult to cancel somebody's cell phone plan without their PIN number or password. And I have had client service reps say, well, can we talk to that person? And I want to say, well, if you can talk to the dead, yes, but it can be very, very difficult. So make sure they're in a secured place, but somebody knows where to find that information, because so much is done online that it's very difficult to track that information down. And I don't even want to know Bitcoin. I've never had to deal with Bitcoin, but that is one that it's all electronic. You don't have those passwords, that's gone. That's gone. So make sure somebody that you trust knows. Where to put the location of your will, your trust. You don't want it in a safe deposit box, because without getting that court order to take to the bank to access the safe deposit box, you can't get to it. So you want it in a safe place, or you want a trusted family member to have that original or know where that original is, that they can access it. Because if you're opening a probate, you need to file that original with the court. So somebody needs to know where those original documents are. do not commingle personal funds and funds from an estate. So I threw this in there in case you're the personal representative for a family member. And usually, the families are very panicked because bills are coming in and they think, oh, I need to pay this. And I tell family members, just take a step back. Creditors can call. If their credit score goes down, who's harmed? What you want to take care of is if you have property, you want to keep the utilities on. You want to make sure that there's insurance on the property. If you can, you want to make sure the taxes are paid. But those last expenses, those medical expenses, all of that can wait. So I just caution, and you don't want to mix your personal money. You don't want to say, oh, well, I'm just going to pay that bill. Because, like I said, you need to file an inventory and an accounting. And so if you have your personal money mixed up with the money for the estate, it makes it really hard to get your accounting to work out. So what you can do, if you have to pay an expense, usually you can get that reimbursed if there's enough money in the estate, but keep those receipts, keep really good records that you're going to turn over to the personal representative or the trustee to request for reimbursement. And then I threw in here firearms because a lot of people don't know that, and firearms are really prevalent here in Idaho. When you inherit firearms, you can't just give the firearms to the family members. You need to go through a gun broker. So you're going to take that firearm to a local gun broker. They're going to then do the background check, and then the beneficiary can get that. There's a small fee, but technically you're not supposed to just hand out firearms. You need to go through a gun broker so that those are registered. So I wanted just to share that kind of with you because a lot of people don't know that, and that's pretty prevalent, and that's really prevalent for the family to go in right away, divide that stuff up, then it's gone, but that's not the proper way to handle it. How much time do we have?
I think what we have.
Okay. Does anyone have questions before I move on to this really sad horror story?
I do.
Mhm.
So, what if we have like a portfolio of different kinds of properties, whether it be short-term, long-term, or just second homes or something? So are you saying, the LLCs are a better way to?
That is something you would want to talk with the attorney about, whether you want to look at an LLC. An LLC is not going to have the language if you're incapacitated unless you've got it in your operating documents. So that is another option. I didn't go down that option, but that is another option to look at, is if you put them in an LLC. Because the LLC is going to have that operating document, and that's going to have the language in there that it carries through. Now, I'm not sure, but if it's held in an LLC, I don't know if you get the step up in the cost basis or how that works. So that's a question.
Okay.
It gets a single member because that's going to be in your personal.
It's kind of
Yeah.
just disregarding.
Yeah. So you would get the step up, but I didn't go down that route. I don't work in this area. I'm kind of more generalist, so I didn't go down that route, but that is also an option that you can talk with the attorney about.
And then one more question. So if you own property with a business partner, and then, like you pass away or your business partner passes away, would it be better, I guess maybe it's a question for this committee, but would it be better to have it held in a certain way?
That would be a question for the attorney, but you definitely need to make sure you have an agreement in writing with the business partner of what happens. It cannot just be a handshake agreement. You need to make sure that that is in writing. And I do know of a gentleman, he and his friend owned a house. Fortunately, they did have it in writing. He passed away suddenly, but his family was very angry they did not get that property. But they had an agreement in writing. I don't know if it was a partnership agreement or what, but I don't think it went as far as litigation. But she had to show that she had the right that when he died, that house went to her, and they did have an agreement in writing. So you want to make sure, I would consult with an attorney, but you need to make sure that you have it in writing. Okay. So I have kind of a sad situation that kind of brings in to how important it is on who you select as your trustee, how you handle things. So this is a local case. And that's really sad. And you can look it up online. But what happened is this woman, she has a master's degree. She was a professor. So she retired from and had Percy from the state of Idaho. She had a ranch with specialty horses. And so she had a good pension coming in and she had Social Security coming in. She hired a young man and his wife to come live on her property to help her with her horses. It's a family friend that they had known a long time that she trusted. She named this young man, gave him financial power of attorney, and as trustee of her trust. She had a health event, went to the hospital. Her friends did not know what happened to her. She was found several years later wandering the streets. A gentleman stopped and asked her if she needed help, reported that it's elder abuse. She was being housed so there was a husband and wife that lived on the ranch that helped her. Once she got out of the hospital, they moved her out of her home and to live with the wife's mother. She said she didn't have access to her Social Security. She didn't have access to her pension. So this young man that, was a family friend and help her, he took her Social Security. He took her pension money. Did he file her taxes and pay taxes? No. The property was paid off. He took a loan out on the property. So by the time my company stepped in she agreed to go under conservatorship to allow someone to help her unwind all of this mess. So over the next 3 years, we had to negotiate with the IRS because the IRS didn't care. She didn't get the money. She had a big tax bill and penalties because she didn't file on time. He took her Social Security, so he took all her income. So when we got in place, we could get her Social Security rerouted to the right place. And that was okay. She still had medical issues, so she was in an assisted living facility, which is not inexpensive. We got a prosecutor involved, federal prosecutor. They couldn't get them for elder abuse. It took about 3 years to get through the court system. They convicted him on wire fraud because he took over her Social Security. But in the meantime, her ranch is out of town. The property is in disrepair. The property now has a mortgage on it. And the mortgage company, when I left and stepped out of the picture, the mortgage company wasn't willing to waive that they were owed that money. So she had to pay taxes. She had to pay a mortgage. The house was in disrepair. And it was really untenable for a woman in her 80s because it was pretty isolated. It was about a mile drive down to her house. So there's no way she could get the garbage out. And it was pretty much untenable. He took all her money. By the time we got through the court process, she didn't have any personal money left. So she didn't have money left to go in and take care of the property to make it tenable. She didn't have money to hire help to help her so she could live independently in the house. And so it took a long time for them to be sentenced. So I looked this case up and he was sentenced to 41 months in prison. The wife was sentenced to probation. So this is a really sad story. And she was a very well-educated, smart person. She had a medical event. She trusted someone that she thought was going to take care of her. But instead, they took over her life, secluded her, and then it took at least 3 years to get her back. But she can never be made whole because now, what she has to live on is just the pension and the social security money. I'm not sure if what they'll do with the house. I don't know if that's come up yet. But it's just kind of highlights to me how critical it is who you put in charge of your financial power of attorney and who you have as a trustee. Anybody have questions? Yeah,
Can you have multiple people be your trustee?
you can. Makes it quite difficult and it increases the cost. So as a professional trustee, we don't like that. But you can, we have trust that we have co-trustees and things work out fine. We have trust that you may have a co-trustee and you disagree and it doesn't work out. It increased the cost because the hours, you're taking, it's easier if you have one decision maker, or you could do maybe 3 trustees and one's a tiebreaker, as a backup. It does, as a professional trustee, that's not our preference. We will act as co-trustees, and I have some trusts that work great with co-trustees. And then I have some that just don't work well at all because they're not as knowledgeable in the area. So then you're trying to, say, okay, you have to present the issue and trying to explain. And sometimes, we have one trust and it's just as simple as we have a co-trustee that has authority over how the funds are invested. We haven't been able to get them invested because he wants the investment to handle one way. Well, trustees, we're governed by the Fiduciary Act. And so when we're handling investments, we can't be as risky. And so that's created an issue and several months of delay of just getting this money invested. And a lot of times you don't get response from that co-trustee. So then you're following up with them and say, have you had a chance to look at this? That's all of that increased those costs. And those are the hourly billable costs. Every time I send out an email saying, hey, did you look at this? What's your opinion? That adds to the cost. So there is some protection in co-trustees. It's very doable. Depends on who you put in as a trustee. If you have a professional trustee that is regulated, has a trust charter, probably not necessary. If you have family members, you might want to consider that more. But from the administration perspective, just know it does increase the costs because now you have 2 people that have to come to a consensus. And a lot of times the trust documents will say a third party can rely on the direction of one trustee, or it's going to say, or do both of them have to sign documents? So, yeah.
Can you have an S corp within a trust?
I really don't know. I don't know why you would, because the S corp would have its own tax identification, and a trust is going to have a tax identification.
What
So-
happens if you're the only owner? You die. And to the corporation.
So if it's an S corp, you're going to go to your operating documents.
Okay.
And usually if you're the only owner, it's going to fall under your estate, most likely, but I don't
Which would
really
be
know.
a trust.
You could have it in it. I don't know how your operating documents are set up, but by default, there is code. It's intestate succession. If you don't have a will or you don't have, but you should have an operating doc even for your S corp. So you would look at your operating documents to see what happens when you pass away. Do you have it going into your trust? Do you have it going into your estate? Because I would think that would be the governing document that you'd have to go back and look at. But that's a question for an attorney. Yeah, so you should have an operating agreement
Yeah,
or
what's the
something.
operating
So look
agreement?
at your operating agreement and see what happens.
Okay.
See what happens.
I die. My two children totally agree on the split. Is there any legal attorney involvement, or do they just take the property and? Oh,
So when you pass away, it's not up to your children to agree on what happens. If you have a will or trust in place,
I do trust.
you have said what's going to happen, and you've probably said it's going to be divided equally to my two children. So it's not up to them, it's up to what you put in that document.
And then they agree to it, and so then is that the end of it, or is there some legality that still has to be?
Well, they don't agree, they don't have the option to agree, because you have said, this is what I want to happen.
They accept what I have put in there, so then is there legality involved in terminating it or anything?
It all depends on the circumstances, so they don't technically accept. It's your decision. When you set it into your estate plan, it's set in stone.
Can I, well, the question, yeah, how does it end?
So,
Nobody
so-
objects, yeah, how do you get to the end of it? Yeah, how do you get to the end?
You just get.
So your trust or will, if you have a testamentary trust, will say, this is to be held in trust. Trust have a finite time, and the attorney can advise how many years, might be like 90 years. You can say it's to be sold at that time. It's to be held for a certain time. So in your estate plan, you direct what you want. If you want it, the default of a trust, it's going to remain there. Trust will have termination language. So it's common and a good idea to say the trustee has the ability to terminate the trust if the costs of administration of the trust do not make it feasible. That gives the trustee the ability to say, we are down to $25,000. This is not feasible to pay the fees and we need to terminate this. And then we would split it. That can be a court process. There is a trust estate dispute resolution agreement. It's basically a settlement process that everybody agrees to, and that is filed with the court. You get attorneys involved, you come up with an agreement. You can terminate the trust, say you want it to go down one generation, but when they're gone, you want it sold and divided between the next generation, you would put that in your trust or your will. So you can decide how long you want it to be in there. If you don't, there is a default for trusts that it's going to stay in there until whatever, I think it's called the law of perpetuities, however long that is. It's quite a long time. It's going to be a few generations that the trust will remain. A lot of trusts that we deal with, usually they're going to run out of funds. So if everything's spent, distributed, the trust will terminate and the trustee will close the trust.
Well, it will run out a lot faster if you're paying a lot of returns, right?
It will. It will.
That would be.
So
one reason
you-
why not to trust.
You know, those are the things, if you know ahead of time, and you can think, how many generations do I want this to be held in trust? If you're gone, it gets really complicated. The more generations, that's usually the more people that have an input, the more shares you have to split. That takes more time, that costs more money. So, I mean, you get to say, you know, how long do you want this in the trust? Do you want to last your kids' lifetime, your grandkids? Mhm.
So to close the trust, is there legality involved in that?
Is it a legal process?
Correct.
It depends, like if the trust naturally, you've distributed everything, it's out of money. Most of the time you can just distribute, you do receipts and releases. If there's a provision in the trust that says the trustee can decide to close the trust because it doesn't make sense, that might involve a court process, because the court process would be there so that anyone that objected to it would have that opportunity to object. So it's very dependent on the situation.
Okay.
And it's very dependent on the state where you're at. So usually as the trustee, we'll reach out to the attorney and say, do we need legal documents to terminate this trust? Do we need to go to court? And they'll advise us, because a lot of it is just so dependent on the situation of why you decide to, if you decide to terminate it early, that's more likely to have attorneys involved and maybe a judge registering that agreement with the court or the judge signing off on it. And that's to protect everybody's interest, that court process. So it's just all situational. That's a very attorney answer of it depends.
They'll just say, come on in for a while, we'll talk about it.
Yeah. Yeah.
The common knowledge is that, and it's probably not very good knowledge, that probate is just an awful thing and you want to avoid it. If one has a very good will, and very well done, is probate, I mean, you still have to go through probate, is that correct?
Well, if everything's in the trust or you have direct beneficiaries on everything, you can avoid probate. My experience is in Idaho, probate is not a difficult process to go through. When you're doing the administration, whether it's on an estate and you're going through a probate or it's a trust, it's very similar. The biggest difference is the probate. You hire the attorneys to draft the petition, to get the court hearing, to get you appointed. And then a few other things, the creditor claim process. In Idaho, my opinion is the probate is not that difficult of a process and it's not that expensive of a process. But I've been doing this for quite a while. So for me, I kind of know what I'm doing and going, okay, we're going to get the death certificates. We're going to collect the assets. We're going to create an inventory. I'm going to do that whether it's a trust or probated estate. The only difference is, what am I going to file? You know, do I go to am I going to file anything from the court? Am I going to get the legal document from the court giving me authority? So in my experience in Idaho, I kind of like the probate process and I really like it for the creditor claim process, because if you have a lot of debt from illnesses, there's a guideline of who you pay, how you pay, and say there's a lot of credit card debt. You send them a notice saying they must make a proper claim to the court. If they fail to make that proper claim to the court, you do not have to pay them. So I'm kind of personally a fan of the probate process because I see that there's a lot of protections in there with going through the court. And then if there's something that happens that you don't like what the executor's done, you've already got that case established with the court and you get a hearing and you go to the judge. So I know a lot of people say probate's terrible. In my experience, it's not. In my experience, it's not. To administer a probate is not any more difficult than a trust. There's a few other steps.
Timeline though, probate would generally take longer.
Not necessarily.
Okay.
So what really takes the time in whether you're handling a probate of an estate or just a trust that's going to distribute everything out and you're going to close it, because a lot of times you can distribute it out, and if you're going to distribute it to more than one beneficiary, especially if they're minors or you don't want to have it right away, you're going to create subtrusts. So you might have this parent trust that's going to distribute out to these other subtrusts, and then you're going to close this parent trust.
Oh.
What takes the longest is getting the final tax returns done. Because as I said, you know, when a person dies, you have to file a final 1040 return. And then if the estate or the trust makes over, estates are $600, trusts, depending on what type of trust, it's $100 or $300, you have to file a tax return for as long as it makes money. So if it takes you more than that tax period to get that distributed out, you have to wait an additional year to get that final tax return filed. So that's usually the last thing that takes the most time. The other thing that gets complicated is the beneficiaries. If they start arguing and you're managing family conflict, that increases your time and increases your costs. And that can be the same whether it's a probated estate or if it's in trust. If you're handling difficult family dynamics, that eats up time and creates a lot of additional expense. So that's kind of where I see. I mean, generally, I will tell people that the creditor claim process in a probate is 4 months, that you should not distribute money. You can handle the personal property, but you shouldn't distribute money for at least that 4-month period. So you make sure you've gathered all the assets and you paid the taxes. Because if you haven't paid the taxes, you're personally liable. That's one of the things that, so if you're an executor for an estate, you're personally liable to make sure those taxes get paid. So you always want to make sure that you have enough money to pay any taxes first. And it takes a long time for the IRS. If tax returns haven't been filed, say you've been ill and tax returns didn't get filed and there's back taxes due and penalties, it can take more time. So you really want to be careful with that, because that has personal liability to you as the personal representative if you don't pay the tax bill. So the tax man's always going to get paid. So I always tell people, give yourself, I go by the probate process, that's a 4-month, to say, you know, I want that time to make sure I know that we've got all the assets gathered. We know what bills are out there, because we do not want to get a surprise with a tax bill that we don't have money to pay. Any more questions? Yeah.
Couple, just I wanted to clarify something that I think you said, to let me know if it's not accurate. If you have named beneficiaries for all your assets and you go through probate, that stays out of public record?
Well, if you have a named beneficiary, that's not part of the probate estate. That's going to be, so if you have a pay on death on a bank account, they're going to take that death certificate into the bank. The bank is going to issue the check right to that beneficiary. It is not part of the trust assets or your probated estate assets. So anything with the named beneficiary goes directly to that beneficiary. It's not part of the estate or the trust unless you name the trust or
You
your
don't have a
estate.
trust, and it just, everything you have goes to probate.
If you don't have anything in place, by statute, it's going to go through the probate process, and the statute says if you have children, it's going to go to the children. It says where it's going to go. So if you don't have anything in place, the statute is going to cover it and say, okay, this is how we handle it.
The other question I had was just for the group. I've been trying to find a trust attorney to speak with, but would like somebody that's maybe about 20 years younger than myself, so I can build a relationship. And I mean, because if they're my age, they're probably not going to be practicing. If I am fortunate enough to live another 20 years, they won't be practicing.
Yes.
So somebody maybe 20 years younger. If there's anybody in this group that has been working with an estate attorney that's maybe in their early 40s, I'd
We
like to
have the
talk to
same
him.
desire. John Bauer, Bauer.
John Bauer.
Good.
Okay, thank you.
And a lot of the estate attorneys that I've worked with over the years are retiring. So it's kind of like,
John's young,
good.
40s.
That's what I need, somebody that's gonna still be around. when I-
Or you want a big enough law firm that they have a transition plan when that attorney leaves that firm, or, they can either leave the firm or retire. What is their transition plan? Does your account retain at that law firm? Does it go with the attorney? What happens if the attorney retires? So that's a good question to ask. If you retire or if you leave, what happens to my account? Because sometimes that business will go to a different attorney that they select.
Well, and just to add one of the other things that not to give too much information, but I'm the last in the family. So when I die, I don't have family that I can trust that's gonna make sure things are done the way I want. So I really gotta find somebody that I trust, because when I'm gone, that person.
So yeah, so you can appoint a professional trustee, and then, if you want, you could distribute it however you want, distribute it to charity. You can set up trusts for your pets. That, you fund money for your pets. I have one right now. she's a big pet lover, so we have quite a considerable amount of money going into a pet trust. We have a pet guardian, and then when the pets are gone, it goes to the Humane Society.
Any suggestions about questions to ask an attorney? We should get an attorney that's up on.
Well, I would ask them, what experience, what's their knowledge with handling real estates and trusts? So I wouldn't so there's a lot of attorneys that they always say they do estate planning as part of their book of business. I would make sure that they have experience in trusts and real estate. And sometimes you're going to have to go to the larger law firms that are more expensive, where they're going to have those attorneys. That solo practitioner that handles a myriad of things may not have the level of expertise. But then there are solo practitioners that focus on, they're a tax attorney. They focus on taxes, and that's a big part of trust. So I would just ask them, what's your experience? How much work have you done in this area? Because you do not want to pay the attorney for their time to learn the law and figure out what they need to do. You don't want to pay for their mistakes. So you want a seasoned enough attorney that has been through it. And, I'd just ask them, how many trusts have you handled? What's the complexity level? What's the assets held in that trust? So that you have a better understanding of their knowledge in that area. Because you don't want to be paying for them to learn what they need to. So I would pay the extra money, get a seasoned attorney. But yes, you want to see, what happens if that attorney retires? What happens to your, where did your file go? Do you have a question?
Yeah, we have first questions, but say we have some mutual fund litigation, and we pass away, they may not, if we designate beneficiary, does that bypass the probation?
Yes, if there's a designated beneficiary on a mutual fund, same with insurance policies, IRAs, that passes directly to them. They're going to make that claim to whoever the investment advisor is, whoever the company is. If it's a Fidelity account, there's a death benefit claim form. They're going to fill out that claim form, send in the death certificate. They're going to work directly to get that death benefit paid. And that is not handled by the personal representative or the trustee. That's not part of it. It goes outside.
So designating that person 100% control, right? In that through a will, right? That eliminates the need for a 50-50 split, kind of where you have multiple people trying to get in. You designated that one person to inherit.
So if you designate, like on a mutual fund, the beneficiary would be your estate or your trust. Okay. So then you would look to the will or the trust document to see how that money goes into the pot. And then the trust document or the will determines how it's split. Does that make sense?
Yeah.
Nice job. Oh, thank you.
Thank you.
All right. So we're gonna do a summary, and thanks to Stacy, she took notes before the meeting. You get to stay up here with me.
Oh, okay.
Yeah, absolutely. So thank you, Maryann, so much. Maryann Duncan, you gotta stand right up here because I don't do this by myself. Yeah, okay, us together. So when it comes to planning an estate, you need to remember to identify your beneficiaries in writing. Ensure that somebody who is trustworthy will know how to access your accounts, your online statements, have the passwords. You need to remember to not commingle your personal accounts with your trust accounts. If you hide your important documents, they should not be in a safe deposit box because you will not be able to have access to that. let's see. Real estate adds another level of complexity. And largely because it requires ongoing capital to maintain it. A capital improvement allocation helps, but so does ensuring that your estate manager is set up to help your heirs manage your real estate and that you decide to leave them. Because we've already probably learned someday we will all demonstrate that not for the faint of heart. And that's it. Oh,
Someone was very creative. I am not that creative of a writer, very technical writer, very just to the point. So, yeah, thank you. So, yeah, so happy to help. My presentation was just based off of my personal experiences, so I did not put the trust company I work for. But Leslie and Stacy know who that is, and if you want to talk with someone, our main office is headquartered out of Spokane. So you would be talking with a person out of our Spokane office, but I am happy to help. I'm happy to put you in contact with them because I believe we do have a group located in Portland, Oregon that does handle real estate and trust. That's just not my area of expertise. So I didn't want to get too much into it because I'm not that knowledgeable, because just like anything, I only have so much time in a day, and dealing with special needs and complex family matters take up all of my day. So I haven't dabbled too much into the trust with real estate. But I believe we do have a team that handles those.
And we did have an AVID speaker last year who is a trust attorney and also works with real estate. So if you would like, I can send that AVID video, because that was really great information. And he was my personal attorney. So when my father passed, he had a will. We were lucky to get that will. And it was the probate process was painless. Dealing with my father's estate was not, but the probate process was definitely painless and was really pretty quick.
It's the family.
It is definitely the same.
I started off with really know who the beneficiaries are. Who is the family that's going to be arguing over things? Are they going to work together? Or do you need that third-party professional person to step in and save those family relationships? A lot of family relationships are destroyed over managing someone's estate or trust. So that's why I always start at know where it's going, who they are, what their personalities are, can they get along? Because that's where your costs really skyrocket.
All right, Sam.
Do you have a copy of that summary?
Yes, I can send it to you. I can email it to you. Yeah, you bet. You bet.
Okay, question. So what if you have a portfolio of real estate in a different state? And then you live in a different state? How
So
would you
make
set
sure
up?
that trustee
Yeah,
is authorized to work in that state. So California is really difficult. So if you have property in California, the trustee has to have a trust charter, not only in Idaho, but they need to have one in California as well.
Okay.
So make sure that you tell them, I have properties in these states. Do you have a trust charter, or are you authorized to do business in that state? Because if they're not, then you come into complexity with, does the trustee have the legal right to go in there on that benefit for your property and do an eviction, say, because that's a court process, and the judge is going to say, do you have the authority to do business in this state? Not all states are like that. California is definitely one. If you have property in California, really get a good attorney who knows California law. It's very different.
thank you.
Thanks, everyone.